Hello, this is Stuart Richland from 420lawoffice.com, and also as part of a legal team. You can find us on Facebook as Legal Team Fights Prop D. Well, the three of us, Graham Barry, Stan Kimmel, and myself, between us we have about 100 years of experience in vindicating people's rights. And the focus that we've had together on medical marijuana has been that we met during the initial battle with the city of Los Angeles when 2 Decembers ago we got a partial preliminary injunction. And the evolving relationship has led me to think that I've really put together a dream team for challenging those aspects of Prop D which are so troubling. So for your insight and so that we can begin to deconstruct the process together of evolving an amazing approach to correcting the problems with Prop D, I thought I'd allow you to join myself and Stan Kimmel as we go over some of the issues we see about Prop D during our preliminary view of it. And at this point we've got well over 9 pages of single-space notes that deal with just about every aspect of Prop D. We will be very honored to hear from you and to make sure that you are in the loop for our upcoming symposium schedule and also our online information schedule. And one of the easy ways to stay in touch is just go to Facebook to Legal Team Fights Prop D, and there's spaces between those words on Facebook, and we'll be very happy to keep in touch that way. And also feel free to call me anytime, and my number's all over this video. All right, let's join this conversation with Stan Kimmel. So I was wondering if you had any particular thing in mind to mention about Prop D that you consider to be, high on the list that of challengeability in terms of its constitutional, propriety or its makeup.
Sure. I would suggest two thoughts. The first is that state law requires a certain procedure from a city if they want to proceed against a business on the basis it is a nuisance per se. That's what Prop D tries to create, but Prop D did not follow the steps that are required by state law. So it's questionable whether the city can pursue Prop D in the way that they wanted to. The other issue I would raise is that the legislature created a zoning power limitation for land use related to medical marijuana, which is a matter of statewide importance since 1972 and 1982, when certain, the state law about maintaining a place for sale of drugs or furnishing a place or renting it, and the state law about nuisance abatement was enacted. Since that time, those have been state issues and not city issues, and it's questionable whether the city can use its zoning power as if it were describing the number of parking places required for a particular business in order to give a permit to build.
Well, that is
I totally agree.
Interesting argument. Do you think that that argument would survive the reasoning in the new Riverside case?
The answer to that is yes. The simple way to say it is that while the city has power to, the city of Riverside recognizes that the city has a power to exclude or to ban collectives, they have to exercise the power in a constitutional way. And we're talking about exercising the power in a constitutional way, which is not considered in the city of Riverside, and is just a universal requirement of exercise of any government power.
Well, for instance, let's say that someone has a collective in the city of Los Angeles and they are facing closure under D. Is it true that they should be entitled to compensation if they are being closed?
It depends on the amount of money they put in, the amount of time they put in, how long they've been at a particular location, and the kind of notice that the city gives them. If what the city has in D right now is just a blanket statement that they must close immediately upon the effective date of the law. The effective date of the law was the date of the election. So while the city may pretend that they've given people due process, this law does not provide that, and so it should be subject to both being invalid constitutionally and being invalid as a taking without compensation.
Right, because when the government takes away a valuable right, there's supposed to be just compensation. Isn't that the basic rule of thumb?
Right, and the zoning law is designed to regulate uses, not to ban uses.
What about using the zoning law to punish? I noticed this criminal law problem that we were talking about.
My personal feeling is that the kind of punishment that a city is allowed to impose is limited to a misdemeanor, $1,000 and a 6-month jail time. The city's ordinance purports to levy a fine of $2,500 a day for every day of operation. That has to be looked at very carefully because it doesn't seem to me that that would be within the city's power to do.
Right, and in fact, under the Minor case that you brilliantly extracted from all the law books in the state, the court said exactly that, that trying to use this zoning and this marijuana ordinance as a way of enhancing criminal penalties, not only does it fly in the face of the Minor case, but it also sort of goes against the whole notion that the state law has occupied the field when it comes to criminal penalties with reference to drugs.
Yes, I think yes to both of those.
Well, let's see. So I don't want to give away the whole recipe because we already have 9 pages of notes, single-space typewritten, about the defects in Prop D, and the other attorneys that might peek in, they're welcome, to what they can scavenge, but we're not going to give the whole recipe because that's our work product. But any other interesting arguments we might want to tantalize the listeners with before I let them know that we are going to invite them to a symposium and get to work together if they would like us?
I'd like people to leave with the understanding that while the law that we're talking about sets the table for arguments that we might make, the most important element of their claims is the particular facts of their case. And you can't just apply the law in the absence of facts. And so the most important thing is to go over with potential clients what events have occurred and what their position is, how much money they've put into a collective, what their patients' needs are, whether they have special kinds of medication, where they're located. For example, in the Melrose area, the city zoning comprehensive plan provides for that area to be a magnet for medical uses. They have Cedars-Sinai Hospital, they have other hospitals in the area, and while the city might, for example, want to limit the number of medical marijuana collectives in all areas of the city, in that particular area, it's expected that there would be an accumulation of medical purposes because of the city's zoning. So things like that will change the result in different circumstances, and people have to be sensitive to that. You can't just make this cake by pulling the box off the shelf and adding 2 eggs.
So it's a custom analysis, and for each collective, and it requires, good lawyering to shine the light most favorably on that set of facts from which then emerge the different applicable theories.
Exactly, and I would like to say that in the City of Riverside case, that factual basis was absent, and so the court talked only about the general law, but they didn't talk about what happens with a collective that actually complies with the Attorney General guidelines and with state law. In the right case law, the court would be able to do that.
Yes, as we say, bad cases make bad law. And when you read footnote 4 in that Riverside case, you can see that the court was dealing with a so-called, not even a collective, that didn't even really comport with, let's say, 99.9% of the Los Angeles affected dispensaries. That fact pattern that they had in there was basically a farmer's market where the patient, the undercover officer, was not even asked to, nor did he join a collective. Okay, there goes my next appointment. We'll talk soon, okay?
Okay. Thanks
Bye.
a lot, Stu. Bye-bye.
Thank you.